everyone, I am Priya Mishra and I welcome you to this week's Immigration Show. First in the show, we'll give you the visa bulletin for September 2011. After that, Mr. Surej Dalal will answer your questions. As you know, Mr. Dalal is a member of New Jersey Bar and has been practicing in our state for over 30 years. Welcome, Mr. Dalal.
Thank you.
Please give us the visa bulletin.
First category, I give you the for family, then I talk about the employment category. First category is the citizen children over 21. It's May 2004, there is no movement at all. F2A category, the permanent resident children and spouse children under 21 is December 1, 2008. It is moved from 22nd July 2008. It's a really good movement, So it now takes about less than 3 years for permanent for a visa petition for permanent resident. F2B category is this permanent resident children over 21. There is no movement at all. It's July 1, 2003. F3 category is the married children of citizens. It's 22nd August 2001. There is no movement at all. And F2 category is the brother and sister of citizen. It's 15 April 2000. There is no movement. Oh no, sorry, there is a 7 days movement. Now the employment category. First category is current and men of exceptional ability. Second category, men who are the masters and PhD, is April 15, 2007. It is moved, it doesn't move at all. Third category is the unskilled worker category, is 8 July 2002. It's moved about 1 month and 8 days. And other worker category, third category is the skilled worker category. There is some movement. And other worker category is the unskilled worker category. Is June 1, 2002. There is no movement at all. All other categories are current.
Any news happening in immigration?
Yes, I tell you one thing. There is one good news, and there is a memorandum on June 17, 2011. And the purpose of that memorandum, I think people now under the impression that the immigration is going to grant all of us a green card. That is not correct. What they want to do, suppose you are in a deportation, and suppose you are in deportation more than, you are living in this country for 10 years, 20 years, and there is if you have some immediate relief, there is no use of deporting you from this country. Because you are paying taxes, you are doing something for this country. So they have made a lot of changes. Because our whole system is clogged up, we have thousands of cases before the judges. There is no use of putting more and more people to be deported. The person who has not committed any crime, they have a good character, moral character, why to remove them from this country? If you are living a long time, I give an example. Unfortunately, I don't know whether we would be in position to be successful, we can do anything. One of my clients came in 1992. And he went, at that time, people wanted some work permit, so they filed an asylum claim. And they thought that's good, they get a work permit. So that's very good. But they don't know, ultimately they have to prove that they have sometimes some problem in India. What people, Gujarati, have a problem to go back to Gujarat? I don't know. So what happened ultimately, the asylum was organized. They started processing the application and his application was denied. So he appeared before a judge and he go to Board of Immigration Appeal and all denied. So in 2000, they asked him to be deported. He has a daughter in this country, he is now married in this country, he bought a house in this country, he is running a business. So he is doing this for last how many years? About 20 years. And immigration decided after slowly immigration caught him in 2008. And immigration department was nice for him. They did not deport him. They put him in they were watching. So we filed ultimately, his brother, his sister, I think, filed an application for forced weapons. And we have the visa date current. So we went and to try to adjust. And the immigration officer says, sir, you can't come here. You can't adjust the status. The reason is very simple, because you are in deportation. So we file a motion with the Board of Immigration Appeal. The motion is generally required within 90 days, but we can't do it 90 days because they got the approval now. So they said, okay, we don't want to grant you any motion because you are too late now. You are too late, about 11 years late. So they denied our motion. And now visa has gone back, so visa is not current anymore. Now they are now, I don't know whether the immigration will deport him or allow him to stay here. We can now, you want to be here, I'm thinking what I'm going to do. I'm going to file a motion now with the Board of Immigration Appeal again, saying because of this new directive from the government, we will file a joint motion now, getting the government lawyer consent, saying that in view of this one, they should give us a consent. And if we get a consent from the government, then probably my client would be allowed to stay here in this country.
Right.
So I don't know. So these are the situation. So what happens, sir? If you are here in this country for a long time, if you have a lot of equities and you are in deportation, probably you can make a motion to the government and probably they stop your case. They won't proceed with your case and put you in. But there is no question of giving a green card. Somebody will ask me a simple question now. He's in this country since 1992. He was put in asylum. Now he's before a judge. Now he had a serious problem, medical problem, all of them. And when I talked to the government lawyer, he said, why don't you file a motion with us and we use the discretion that he should not be deported. But he won't get a green card. He wanted a green card. I said, there is nothing, nobody can help you to get a green card.
So then what is their status? If they're here, but they're not on green card, what is their status?
Probably they may give them a work permit.
Okay.
I don't know. They may give a work permit. They won't deport them. If they think this man is going to be qualified or something. What is happening in immigration, I tell you. Government, we have two sides, Democratic and Republican. Republican oppose anything what the Democratic does. What the state governed by Democratic, they have been very reluctant to allow any immigration law to be passed. But two states, Texas and Illinois, they passed their own Dream Act.
Okay.
And they said any student who are illegal in this country, they will give them a grant and scholarship and everything. And they can go and study in college. So what do you use them, when you're wasting the talent of young people? So these two states where are run by, I think there's a democratic government, they are more enlightened. I tell you that should be followed by New Jersey. That should be followed by New York. Because we have more immigrant population here. And our children are here. We have, because unfortunately they came here in this country, they should be allowed to go to college. They're smart.
Yeah, and they came as a minor.
Some of them, I tell you one thing, I know one case, they are so smart they can become a doctor.
Absolutely.
And they should not be prevented.
Absolutely.
Because it's not a fault of their children.
Right.
Okay?
All right, with that, let's take a short break. We'll be right back after these messages.
About 10.
Asia.
Welcome back. You're watching the Immigration Show on TV Asia. Shall we get started with the letters for today?
Yeah.
Okay, first letter is from Ali Khan. He says, I am 39 years old, British citizen living in London, United Kingdom, and I have my two sisters and a brother living in USA as US citizen. One of my sisters is running her own business, but now she is thinking of retiring from the business and she would want me to take over her business and run it for her. Could you please advise how I could go about getting myself migrated to USA? Can my sister sponsor me, or will it be better if she gave me a job offer so that I can work for her on a working visa? Please advise what is the quickest and easiest way of immigrating to USA. Many thanks in advance, and I look forward to hearing from you soon.
I'm sure this man must be a British citizen. I don't know.
He says British citizen.
If he's a British citizen, there is a visa, we call it a TT investor visa. What he can do, he can acquire 51% interest in a sister business.
Okay.
And make an agreement for payment of money. And he acquired 51%. And we can file E2 petition for him. And he can come here and he can take over the business. There is no other way he can get it, because if I file through the employment category, it will take about 10 years.
employment category.
Yes, if sister file him to employ him in a business, it will take about 10 years because the visa number at present is 2002.
But with the H1 as well?
H1 is only for a qualified people who has a degree, and you are going to work as a
So we don't know his
But this is a business. This is not a technical.
education.
This is not a business. A technical retail shop. That doesn't need professional people. H1 is only given to professional people. They are going to do the professional type of job,
Right.
not running a candy store. That is or a stationery store. That is only given in Canada, not in the United States. So you have the only visa there available is the E2, TT investor visa.
Okay.
And that should be explored, that situation should be explored.
But now the money has to come from...
Probably can be worked out, because the investment, he doesn't have the money, suppose his
Right.
sister is going to say, this is my price, how much there, and he said, I'm going to pay off this money. The money should come from England, I agree with you.
Okay.
But the question is that can we also work out on certain basis, because his investment would be there, he's liable to pay. And the law doesn't say that money should be, this question is, they said it should be substantial investment.
Okay.
He said, this is my substantial investment, my sister has given, sister can give him a gift.
Oh, okay.
Yeah. So this is that, he doesn't
For
have
the
to.
visa purposes, she can give a gift?
Yeah. He said, listen, I'm giving a gift of this, the total value of story is about $500,000. 250,000, I'll give you a gift. Or he can make some kind of agreement, a promissory note or something. Okay?
Okay. That, Mr. Khan, I hope that helps.
I think it should be, before this situation should be explored, they should consult a local lawyer and then should get the opinion. I don't know whether he has money or not.
Right.
If he has money, there is no problem.
There's no issues.
Then whether this route can be done or not, that's a question to be decided. Okay?
Right. Okay. All right. Next letter is from Mr. Ravinder Singh. He says, until last month, I watched your program regularly on Dish Network, channel 788, but no one has yet asked a question like mine. I had to disconnect this channel because of financial stress. I need your help and clear opinion at this stage of my immigration status. I am sure you will do the needful and do us a big favor. The background is myself and my wife, place of birth in India, but we acquired Canadian citizenship when we were living there. Our two kids, 22 and 17 plus, are born in Canada. Entered USA on TN visa in September 2004 from Canada, acquired H1B in September 2005, valid for 3 years. Labor got approved in PERM system in June 2006. I-140 was approved. Filed I-485 in July 2007 and I got accepted and we got our fingerprints done at the USCIS Approval Center. Renewed my H1B and dependents H4 for second time in September 2008, which is good until end of September 2011. Daughter's H4 was renewed until she turns 21. Now she is under CSPA category. We are maintaining our EAD, which are renewed every 2 years. The main questions are, first, when I-485 has been filed and accepted in 2007, why do we need to renew our H4, H1B and H4 again and again, even after 2 renewals? Second question is, if we do not renew our H1 and H4, will they continue to renew our EAD or they can decline that when it's due next year? Will we be considered out of status or illegal here? Filing an application to renew H1 is like applying for a new H1B, as it demands to attach company profile for which we are working, company financial details, my biodata, again job description, and with all that filing fees, which is so expensive and it is very cumbersome. Elder child, who is 22 now, was below 18 years of age when our I-485 was approved by USCIS. So she is under CSPA and she is continuing her college education. Please help us and guide us.
One very interesting question is this one. That when you got an H1, you are already out of status. When you apply, you come here, when you apply.
Right.
because you are being protected because of your filing H1 status. Once you go out of H1 status, you are no longer can adjust your status. So you have to remain in status. Anyway, you have to remain in status. I know it is very expensive. I think third preference is moving very slowly. I don't know how many years it will take, but I know the expenses are there. You have to pay the money. You have to get it done because that is the law. Because by filing 485 and I-140, that doesn't protect your status. That is allow you to adjust your status, but you have to remain in status. If you therefore, this is a very important thing that you have to remain in status. Now the second very important question about a daughter, which is giving me some problem. Okay. You know, the law is, as far as I know, the Child Protection Act doesn't froze the age.
Right.
Means when she was 18, suppose she was 18 when I-140 was filed, the age is not frozen. If it's frozen, then there's no problem. But if age is not frozen, whether the Child Protection Act gives her help, how much help she can get it under the Child Protection Act. Take an example, under the Child Protection Act, if they have taken I-140 approval 1 year, she get maximum 1 year extra. Suppose you've taken 2 years, she will get 2 years. But suppose at this rate, she won't be, I don't think they were not taking that long time to approve I-140. So I don't know how long, we don't have an idea how long I-140 took a place to be approved.
All right, on that thought, let's take a short break. We'll be right back after these messages. Welcome back. You're watching the Immigration Show on TV Asia. Our next letter, we don't have a name for the viewer. हिंदी में लिखती हैं, सबसे पहले तो हम आपका बहुत धन्यवाद करते हैं और आपके बहुत आभारी हैं कि आप बहुत अच्छा प्रोग्राम पेश करते हैं जिससे लाखों लोगों को राहत मिलती है और हम आपको लंबी उम्र की दुआ देते हैं। मेरा प्रश्न मेरे बेटे के लिए है। मैं यूएस सिटीजन हूँ और कैलिफोर्निया में रहती हूँ। मेरे हस्बैंड ने नवंबर 2007 में मेरे बेटे की पिटीशन फाइल कर रखी है और उसकी वाइफ और 2 बच्चों का नाम भी उसमें भर दिया है। अब प्रॉब्लम यह है कि उसकी वाइफ बच्चों को लेकर सेपरेट रहती है और डिवोर्स मांगती है। मेरा बेटा बच्चों को चाइल्ड सपोर्ट दे रहा है, अभी डिवोर्स चाहता नहीं है और दूसरी शादी भी नहीं करना चाहता और अकेला रहता है। बच्चे वीकली उसके पास आते हैं। हम आपकी एडवाइस चाहते हैं कि अगर वो डिवोर्स करता है तो नंबर आने पर इमिग्रेशन को कोई प्रॉब्लम तो नहीं हो सकती। इंटरव्यू अकेले ही दी जा सकती है या वाइफ को भी कुछ प्रश्न पूछेंगे क्योंकि वो तो आना नहीं चाहती और ना ही बच्चों को आने देगी। कैटेगरी तो चेंज हो जाएगी जैसा कि आपने बताया। डिवोर्स के बाद जब वो प्रूफ मांगेंगे तो बच्चों के लिए भी कोई प्रूफ भेजना चाहिए ताकि बच्चे बाद में उसके पास आ सकते हैं। चाइल्ड सपोर्ट तो वो यहाँ आकर भी दे सकता है। हम आपकी एडवाइस पर जाएंगे। मेरा बेटा ऑस्ट्रेलिया में रहता है और न्यूजीलैंड का सिटीजन है। अभी तो मैरिड बच्चों को बहुत समय लग रहा है। अगर एक साथ रहते तो कोई परेशानी नहीं थी। आपका बहुत बहुत धन्यवाद।
ये केस में आपको ऐसा लगे कि शादी खत्म हो गई है, वो अभी जोड़ सकती नहीं है, तो डिवोर्स लेना बहुत अच्छा है। डिवोर्स से क्या फ़ायदा होगा कि इसका नंबर जल्दी आगे लगेगा। अभी जो अनमेरिड चाइल्ड ऑफ ए सिटीजन 2004 चल रहा है तो जल्दी आ सकेगा। दूसरा जो है कैटेगरी बहुत स्लो मूव कर रही है। तो मेरी एडवाइस है कि आपको लगे कि अभी ये शादी में कुछ नहीं होने वाला है तो ये। दूसरी क्वेश्चन ये बड़ी है कि बच्चे की कस्टडी तो न्यूजीलैंड ऑस्ट्रेलिया में दे आर नॉट गोइंग टू गिव हिम माय कस्टडी। अभी सोचो ऐसा कि इधर आ जाए तो इधर से चाइल्ड सपोर्ट तो दे सकेगा। वो क्या कर सकता है कि बच्चे की कस्टडी में जब भी बच्चे कितनी साल के है, जो बच्चे की उम्र 18 साल की हो जाए, he should file the papers for his children. और he
18 के हो जाए।
अभी भी he can the children are there. He can qualify to come to join him, provided because now they file a petition. He can, what he has to do. There is a question of follow to join. He can file an application after coming here to follow to join. That application will go there. He has no custody, so they won't allow him to come. But he should file the application, follow to join. I think that application there, so children right would be still maintained. Or if he thinks after coming here, he can become a citizen and can file again another petition. But children, at present, if he can get a custody, he can bring the children here.
Right.
And I think he can work out some sort of a deal with a wife that I take the children there and send it back to you. At least allow them to have a green card if they want to settle.
Right.
Now it's very
Reason करना चाहिए wife के साथ।
very difficult is. Australia is a good country. New Zealand is a good country. America is a good country. You have to choose now which country you have to settle.
Right.
They are lucky that they are not in like Pakistan or something other country. They are in a very advanced country. So you have to think, if the son wants to come here, the divorce is, in my opinion, the best course. Okay.
So, just to recap in Hindi, divorce ले ले क्योंकि फिर वो जल्दी आ सकते हैं यहाँ पर, और बच्चों के लिए यहाँ आके फाइल करें
follow to join
application, और फिर अगर वाइफ के साथ अग्रीमेंट हो सकती है, दिस इज अनदर ऑप्शन। सेकंड ऑप्शन ये है कि वाइफ के साथ अग्रीमेंट हो सकती है तो बच्चों को साथ लेके आए, एक बार ग्रीन कार्ड हो जाता है फिर बच्चों को वापस भेजते वाइफ के पास। इज दैट करेक्ट?
That's correct.
So they can work this out in divorce agreement.
Yes.
When they do the divorce agreement, they can work this
Sure.
out. Right. I think that's very sound advice. So I'm sorry, I don't know your name, but I hope this helps you. And I know divorce is not something that the parents want for their children, but
I know.
and he obviously doesn't want it from his wife.
But he can do, he has no
But
choice. If the
it
marriage is not.
resolvable,
Yeah.
then it's best for his interest to get the
Yeah.
divorce. Okay, our last letter for today is from Mr. K. Shah. He says we filed for, just to recap that situation, they were here in 2000, but their US 245I, the Life Act by Clinton's Law 2000, was denied in March 2009 because they traveled to India on 19th of December, not meeting the basic 21st December physical presence in USA. He says, he's written to us quite a few times. This time he says, we filed for cancellation of removal on 28th of July 2011 as we completed 10 years in USA since 1999. My son got his green card after marriage with citizen girl in July 2011. What are the chances of getting green card on hardship waiver for me, my wife, my green card holder son, and citizen daughter-in-law? Moreover, I-130 is approved in July 2009, which was filed by my wife's brother in 4th category in August 2001. We can now go back to our home country to resettle as there is nothing over there for us. We have a well-established business since 2003 paying income tax, no criminal record. Please guide us. Our next hearing is on October 20th, 2011.
I know Mr. Shah very well. He came and consulted me.
Right.
He was in my office. Now we have the memorandum of June. My best advice is, suppose if he thinks that it's, I don't know what judge is going to do and all this thing, he should use that memorandum of June 17th and make an application. Ask the prosecutorial discretion to be used, so he should not be deported. And he can cite all the facts. Ask this removal proceeding to be terminated if he thinks he's going to lose the hardship waiver. And then they have a chance, because he's really a good case, they may use it and they won't deport him.
Okay.
Okay? So what happened, my advice is, I don't know, I advised him to consult an attorney last time when he was in my office. You ask him to file a motion with the judge, with the government, ask the government lawyer to join motion.
This will be prior to his hearing in October.
Yeah, prior hearing, that the removal proceeding, he should see how his case is going on about the conditional, removal of the, he has filed a motion, for removal, cancel of removal, and then in that motion you have to go hardship, and if you think there is not enough hardship, then there would be probably going to lose it. Now why don't you, before go to Board of Immigration Appeal and argue there and all this thing, better make a motion. They use the prosecutorial discretion, prosecutorial discretion to stop all the paperwork, the removal proceedings, and stop everything, and tell him that he could have a good chance ultimately is going to get a green card here. What is the use of deporting? They may administratively, they may close his case, and he may have a chance. It's a good case to argue under this one, the guidance which was issued on June 17th.
Great. Okay, Mr. Shah, so you can reach Mr. Dalal at his office to get a copy of the memorandum that you need to use for the motion. With that, we come to an end to our show. Here's a quick look at the priority dates for September once again. Here's our address where you can send us your questions and or suggestions for the Immigration Show on TV Asia. Our address is 76 National Road, Edison, New Jersey 08817. Our fax number is 732-650-1112. Our email address is immigration@tvasiausa.com. Please remember, we do not respond to any letters by mail, by email, by fax, or by phone. When writing to us, please let us know what city and state you're watching us on. Are you watching us on dish or cable? What is the name of your cable company and the cable channel number? Please allow at least 4 to 6 weeks for us to respond to your letters. Once again, I am Priya Mishra, and I thank you for joining us here today, and thank you, Mr. Dalal.
You're welcome.